So, ladies and gentlemen, welcome. My name is Tim Fairhurst from the European Tourism Association, and this webinar is entitled Risky Business, Collective Redress in the Tourism Industry. That sounds very technical. To some extent it is. It's also a very practical issue for all of us in the industry who are seeking to manage risk in an intelligent way, and also for those of us in trade associations like ETOA and also ECTAA, who are seeking to influence policy development both at a European level and domestic implementation. And one of the issues that will become clear today is that whereas some European countries already had a framework that provided recourse for collective redress, some EU countries do not. So that represents an opportunity for professionals, for trade associations to influence domestic legislatures in the decisions they make, in the options they have implementing the EU directive at a domestic level. Without any further ado, I'm going to ask my panelists very briefly to introduce themselves. There will be a third panelist, Benoit from ECTAA, who will introduce himself later. He will join the discussion, but the formal presentations will be delivered by Olivier and Dora. I'm just going to ask Dora and Olivier in that order to introduce themselves briefly, then Olivier will start us off with a formal presentation. So Dora, then Olivier, off you go. So Dora first, welcome.
Welcome, thank you so much, Tim. Good morning, sunny good morning also from Hungary. Unfortunately, I'm not here, it's just my virtual background from our beautiful Lake Balaton, but it's so good feeling to welcome all of you around Europe and especially colleagues and all representatives. Thank you so much, first of all, to ETOA team and ECTAA that we organized this webinar today, because we also think it's a very important moment. At least we have a new EU legislation, but before the national implementation. And I think the main important objective of today's webinar, a common brainstorming to raise the awareness to all of you. And we hope so there will be a vivid chat after the short presentation. As Tim said, my name is Dorothea or Dora Janizsa from Hungary. I have two hats actually, because I'm representing today a tour operator, a local tour operator, OTP Travel. We are a leading tour operator in Hungary, actually dealing all the branches, corporate and leisure tourism. So I think I can add you some practical examples concerning this new legislation, but I'm also representing the Hungarian Association of Travel Agents, and I'm chairing there the legal committee, but today I just forget my lawyer position. That will Olivier who will do. Thank you.
It's a lovely link to Olivier. So Maître du Gardin, if I could ask you to introduce yourself and then start the presentation. Olivier, over to you. Welcome.
Thank you, Tim, and thank you for organizing this seminar. For those who don't know me, I saw some familiar names in the list of attendance, so I'm very happy to be here and to present or to participate in this webinar on class actions. I am a lawyer. I'm based in Brussels. This subject is a bit of a special subject for me, because as a coincidence, I'm also a judge at the Court of Appeal in Brussels, and we are actually competent in class actions since 2014. So I have a bit of a double hat. So we're going to talk about a subject that I think will raise a lot of questions, and I will try to answer them all as far as possible. So by way of introduction, ETOA has asked me to give a little bit of a background about this directive and also the key elements of the directive, especially because I understand that this audience is not only composed by lawyers. So I will put on a small PowerPoint presentation that I have prepared, if you allow me. Do you see it?
Yes, that's all clear, Olivier. Thank you.
All clear? Well, so there we go. So this directive is about representative actions. The first question we may ask is, what is a representative action? Well, under this new directive, the representative action, or more commonly named this class action or mass action, is a legal action that is initiated by a so-called qualified entity on behalf of a group of consumers, whose collective interests have been harmed by a trader, with the aim of seeking an injunctive measure, a redress measure, or both. What is an injunctive measure? That is seeking to stop some unfair trading practices or an abusive contract terms, or for instance, a misleading advertisement. What is redress measure? Well, redress measure is about money. That's seeking money, seeking to obtain compensation, damages, or price reduction. So for many cases, it is indeed not very practical and extremely expensive for a consumer to sue a trader for, like, for instance, 200–300 euro. So the idea is that when the common interests of a consumer are harmed, that they could act together. So this new directive, there was already a directive existing about injunctive measures, but this new directive has another purpose. It is larger. We have to know that today 18 of 27 member states in the European Union have some kind of class action in their legal system. But believe me, the rules are extremely different. That also means that 9 member states have no system at all. So we see that, for instance, some countries, there is a system since 2014, 2015, then this one when it's more or less started, with very different rules. Holland has a pretty hardcore class action system, I have to say, Belgium as well. France is a bit more different, but the rules are very extreme. So this is maybe one of the reasons why these class actions have a limited success. Most of the cases are national. There are no cross-border actions, or very little. I haven't found any, I think there are even none. And there's little case law. I will come back to that. So there was actually a turning point, and that was Dieselgate. Dieselgate pushed the member states, but also the Commission, to go forward with this direction, because we realized at that moment that consumers are very vulnerable. Because consumers wanted to act at a European level, but they couldn't because of the unequal access to justice across Europe. Because, as I said, in some countries, there was not even a system of redress, of collective redress. So what is the primary goal of this directive now is to make sure that there is in every member state at least one mechanism, a procedural mechanism, that allows representative actions, class actions, but also that cross-border class actions will be facilitated. What is extremely, also the rest of the debate, what is extremely important to understand, and that was a choice of the legislator, European legislator, is that this directive is directive of minimum harmonization. And I would even say it's a very minimum harmonization. And that's really important. The directive does not touch upon the system of about the principle of procedural autonomy of national member states. In fact, the directive doesn't create a new system, doesn't create a new class action system like you have in the United States. It only sets out minimum standards for procedural rules for class actions in member states. Only minimum rules. The consequence of this is that there is a very large margin from transposition for implementation of the directive by national authorities. They will certainly come back to that. And 2, there is a true risk that national redress mechanism will remain extremely different and that the directive will miss its goal. So this is why I think this webinar comes at the right time, because not only we are in the middle of the implementation phase, so there's still a possibility at national level to try to do 2 things, try to have a more common system at the end of the day, and 2, also, for industry to put some accents on some matters that are not covered by the directive and that are of a great importance for the future, as you will see. So very briefly again, because the idea of a panel is a debate, but this is important so you understand how this directive works. What are some key principles? 1, the class action can only be initiated on behalf of consumers, and consumers are defined in the directive. It is a natural person who acts for purposes which are outside of his trade, business, craft, or profession, which means that basically business travel is excluded. And I opened already a little bit of debate. What about passenger rights? If you want to start a class action, If, for instance, passengers travel for business purposes, actually it won't work. Well, that's for the debate for later. So 1, consumers. 2, class actions are only possible against violations of EU consumer laws. These consumer laws are listed in Annex 1 to the directive. I have to say it's very large, so it covers a large variety of areas: product safety, financial services, telecommunication, data protection as well, environment, but also specifically travel and tourism. And as you know, travel and tourism is a little bit on the radar of the Commission right now, because after the pandemic, the Commission have realized that in the sector, consumer rights have not always been, I would say, respected, even a bit challenged by, for instance, non-reimbursement of cancelled flights. So the Commission is extremely aware of, or very much focused on travel and tourism for the moment. These are the areas, but they can be extended by the member state. Okay. Next principle, there must be an infringement of a collective interest, which means you need a group. Collective interest of consumers means that the general interests of consumers are harmed. So it must be a collective infringement. But then again, what is collective? What is collective? You need a group. What is a group? Is 10 people again is sufficient? 100? This is again up to the member states. The member state can define what is a group. And also, obviously, an action can only be brought against one clearly identified infringement, one cause against one trader. So it has still limited focus. Another very important principle is that a class action can only be brought by qualified entities, which must be recognized by member states. The purpose of this is, of course, to avoid abusive litigation, American-style class action suits. You all know, for those who read the books of John Grisham about class actions, we don't want that kind of situation in Europe, with lawyers flying with their private jets to go all over the States to get some consumers to get a maximum of amount out of the traders. This is something that has to be avoided. It is the member states who decide who is a qualified entity. For domestic qualified entities, the member states are completely free to set the criteria. For cross-border QEs, that's the member states also competence, but there are some minimum harmonized criteria, such as you have to be non-profit, independent, you need to have 12 months activity in consumer protection. Actually, this is a very special law in European law, a very special instrument because it is exceptional. You have a QE, it is a qualified entity who is a claimant, who decides what cases to pick. It is the qualified entity that can shop around and say, I think I'm going to sue this company or this company. They decide because the consumers are not a party to the case. They are beneficial, the beneficiaries of the measures, injunction or financially, but they are not party to the case. Then the final, or one more, is of course extremely important. You see that already now in practice. Is a class action opt-in, opt-out, or both? Well, today there is a variety of systems, and that is crucial, really crucial for the functioning of these cases. What is an opt-in? An opt-in is that the consumers must agree to be represented. For instance, we had a case in Belgium about Proximus recording systems. Well, of course, the consumers prefer that it is an opt-out. Opt-out, this is when the consumers are automatically included unless they don't want to be part of the action. Of course, a consumer organization will try to have a maximum of consumers and prefer the opt-out mechanism. Yes, but the opt-in mechanism is the other way around. You have to be motivated. You have to be actively accepting to be part of the system. One little remark is that for the I would say, if a consumer is domiciled in another member state and want to attend or to participate in class action in another member state, it is always an opt-in mechanism. So final remark is, I mentioned that already, the European Commission clearly is afraid of US-style class actions, very clear. because it's all over the directive. It is in the text, it is in recitals. And what kind of measures the Commission tries to put in the directive to avoid abusive procedures is one, I mentioned that already, only qualified entities can bring actions. One. Two, there's a big discussion about that, is the party who loses the case will have to pay the costs. As you know, in some countries, legal costs are always capped, are always limited, but in some countries today, there is discussion for class actions because sometimes the amounts are very big, very large, not to cap, to uncap the legal expenses, which of course makes consumer organization of QEs, qualified entities, think twice before launching a class action. Three, the directive mentions that punitive damages, you know what punitive damages is like a financial fine that is asked to be put on the trader, should be avoided. And finally, the directive allows third-party funding. We will come back to that maybe, because this is a tricky one. That means that somebody else can finance, can fund a class action. This could be a competitor. It's very dangerous, by the way. So third-party funding is allowed. It is up to the member state to allow it or not, but the directive introduces certain parameters to avoid conflicts of interest and diversion of the final goal of the class actions, which is, of course, consumer protection. So, Tim, this is a little presentation. I have one more slide, but maybe we can use that in the framework of the debate, because I have made a little list, not exhaustive, of matters where the directive gives the member states a lot of freedom to decide. And that's only a short list, because I could have made like maybe 4 or 5 slides, but the bottom line is that there is a huge liberty, a huge freedom in the hands of the member states to complement or to adapt the directive to their own needs, to their own procedural needs. So, Tim, I will stop here to make room for the discussion.
Okay, Olivier, thank you very much for a very clear summary of where we are now and what the scope is, and also what the options are at a domestic level. Before I'm looking at the chat, no one's got any specific questions. I've got 2 questions before we pass on to Dora. And I know some of our audience will be businesses based outside the EU, and a lot of the consumers will also be non-EU. So may I ask, does this cover non-EU consumers if the fault takes place within the EU?
You start with complicated questions, but this one is okay. No, I think if you are not EU trader, you are not subject to this directive, but the consumer is defined such as it is in the directive, and there is no limitation. So when you buy a travel service or package or whatever in Europe, you are protected by this directive as a consumer. Great,
but that's reassuring for non-EU enterprises to know. And a related question on the notion of the qualified entity. Is it the case that the member state must expressly approve and recognize, I recognize that consumer organization as a qualified entity, or can someone choose to set up an organization whose purpose is, for example, to pursue cross-border actions in this area, and they just, you know, that organization says, look, we comply with the requirements of the jurisdictions we work in, and they actually do not need any express government recognition. So can someone just set themselves up as a qualified entity?
That will depend on the national government again, because a qualified entity has to be recognized by the government, by the national government. I don't know the system too much in the other member states. For Belgium, there is only one actually. It's the Testacha, who has been chasing a lot of cases in Belgium. We'll come back to that. But you can create in Holland, for instance, the consumers can, for the time being, can set up like an ad hoc committee, which is in Belgium not possible, and in other countries not possible. So there's a variety of systems, and I'm afraid that will stay a little bit like this in the future. But to answer your question, qualified entity has to be accepted, has to be recognized by the national government. I add to that, and that's another question that will maybe come back later, that in some countries the qualified entity is a qualified entity, but in Belgium it is the judge who can refuse the qualified entity. So if the qualified entity comes to court, the judge can say, I don't like you, or you're not the right qualified entity for this kind of class action, so he can refuse the admissibility of a qualified entity. But also this is open for implementation. But in that way, we have only one major qualified entity. If you refuse it as a judge, what do we do?
Great. That's very clear. Well, you're stuck in terms of this directive has no teeth in Belgium if you didn't recognize identity. But I think that underscores your earlier remark that we're not looking at a US style lawyers flying around the continent looking for opportunity. This is a very different scenario we're considering. So Olivier, thank you for that. We'll come back to the national implementation questions later in the debate, but I'd now like to invite Dora. We'll try not to be distracted by the gorgeous view of Lake Balaton and focus on the what is the view from a tour operator of what's around the corner here. Over to you, Dora.
Yes, exactly. Thank you so much, Tim. So I think I'm already sharing, right? Can you see the screen? Just the feedback?
Yes, we can see the screen.
Thank you. Thank you. It's always a fearing. Yes, so again, welcome everyone who was not by the introduction part. So yes, today I try to focus purely as my tour operator's role. It's not easy, that's true. So what I did, as Olivier already presented the legal background and all these provisions, I also have a deep look, of course, in this new piece of legislation. And I try to identify, first of all, the current system we have, as Olivier presented, that 18 member states already in the European Union, including Hungary as well, we do have some similar forms or actions that we have to face. This is the first slide. And then the second one, that we try to a little bit make some brainstorming what kind of activities, what we are doing in the travel market or products can be included or has an effect by this new legislation. So therefore, we have to be very well aware in the future. So about this current situation, as we know, we tour operators and the travel market are affected by many legal acts, not just purely the travel law based on the package travel directive, but we also have to follow consumer law and of course in the different system, but civil code in every member state is very, very important. So right now in Hungary, we have some similar actions we have to face or in practice regarding our customers or consumers we are talking about. So first, which is based on this former EU directive, which we repealed by this new one, the so-called public interest action. Right now, consumer associations and here in Hungary, public prosecutor is just a technical matter, can initiate this kind of action. But there is this big difference because here they have to prove, first of all, a significant number of consumers. So I think that will be, when we are talking about the future modification, that will be easier for the future, because here in Hungary, for example, in the jurisdiction and the courts are examining and making certain requirement. What does it mean, significant number of consumers? So we are not talking here about 20, 30 people, but it's depending on every case. And there is another requirement that must be a breach of a consumer law provision. And what is the big difference? And that was Olivier already emphasized, that here we are just talking about the injunctive measures. So they also make the establishment, they public that there was a breach of consumer law, but not necessarily means a direct compensation or remedy at the same time in the same procedure. So that will be a big change, I think. The second form what we have in the current practice is the so-called action, when I think maybe some of you already faced this at the national level, when an unfair standard contract term was established by a court procedure. This is also much more of the public interest. We all know we have to use a very careful general terms and conditions think about the PTD, for example, so many pre-contractual information obligation we should follow. We have to be very precise in the travel contract. So that's very easy. Sometimes it happens. Here in Hungary, that's a common case, or could be, but this is pure, again, about the injective measure. So they have to stop and they have to modify, for example, this kind of unfair standard contract term or behavior by the service provider. I made some investigation lately. We have some cases, but that was much more for a timeshare provider, not by a tour operator. We very carefully help and assist our members, for example, in the association, the TO members, just to help and see that, look after always and review the general terms and conditions, especially now, such a very, very challengeable time we have after the post-COVID area. So we must be very careful, but I will talk in, later as well. And what is working very good, and I think we've worked a lot, everybody on that, the so-called ADR, or sometimes ODR system, the online version, the alternative dispute resolution system. But this is much more for individual cases, right? So the travelers, here in Hungary, arbitration works very well. Of course, all of the TOs, I think, who are present with us, we all have this objective, and we try to negotiate first of all with our travelers, right? If any complaint happens, of course it could happen, but first, of course, there are many complaint management systems, especially by the big companies, but also in other companies, to follow at the first stage. And it's always better at the first stage to go for an arbitration and not involve, of course, a very long court procedure. So I can tell you that here in Hungary, the national system ADR is working well. So there will be also a question, if I move on for future, what will be actually with the ADR system in the future. So when we are talking about the main issues, what we identify or try to understand, which could be a problem or a threat for us as tour operators, and especially in the travel market, first of all, as we're talking about collective redress and collective group of consumers, we don't talk about FITs or individuals. So tour operators who has a strong group travel segment, that could be an issue. So with a group travel, okay, we are not talking about, again, hundreds or 1,000 participants for one tour, but group travel activity can be an issue. We all know the situation when 20, 30 people are together and there is only one traveler who starts in the group, even during the trip, try to urge the other people and making complaint, go back home and try to make any compensation, even if it is not justified. So we have to be aware, and we have to be more prepared for such kind of action, because the action could be easier, as we heard, by the legislation after the implementation. Second point, as I already mentioned, the ADR system is, again, is just a question in the air. What will happen? Still, is it good for the individual travelers? I think it will be capped, so we have to follow that. So the arbitration system has no more effect. Even this collective group redress will be implemented. So I think, or I assume, we should go ahead and use these forms as well. Telling the truth, here in Hungary, the online version is not working very good, or we haven't got so many cases. I don't know your experiences from other member states, but this is just an off-topic of today's webinar. The third point, as raised by Olivier as well, the cross-border issue. And that could be, we should also talk, because especially in certain regions in the European Union, we all know airports which are very close to each other, member state borders. It's a normal operation that the tour operator in Hungary also sell a tour operator package from Austria. I'm just telling you a very practical example, but that could also happen all the different regions in the European Union. So the cross-border activity and such kind of business model can be an issue, especially because we don't know that how the national member state will implement this rule. And as Olivier said, it's a minimum harmonization. So we all know the experience with the PTD, that how that started many years ago and what happened by the modification. So that could be the case. So maybe the tour operators who are based in a certain member state and operating cross-border, maybe after that they should have a look on the implemented legislation to avoid that not be easy to start a kind of activity, especially if they have group traveling. What is very important, point 4, what I said also by the introduction, awareness. So I think this is now our one of most important work and objective, especially if you are part of an association and organization, make awareness of your members, for the TOs, that even after the implementation of this EU directive, we have to be very, very careful, how to draft and what to include in the general terms and conditions, precisely follow all these, not to make, I would say that, an easy basis, you know, an easy basis for a kind of class action. So review, contractual provision, I just include, of course, the information obligation, which is again a very, very, very hard job, especially nowadays. We all know what we have to face, but I think that's like a practical advice first of all, because that's very easy to justify by a class action. And I just added a last point, because I had some exchange negotiation here locally with the consumer association. How do they see the markets and maybe the future of this new legislation? And I also had some remarks by the Commission when they have this feasibility study on this new legislation. And it is anticipated that much more the airline industry will be affected, not purely the travel market of course, but as we all know, we are in the same market. So actually we work with the airlines as well. It is also depending on the group and the number of the passenger. And as Olivier said, there are many questions still in the air. How will be affected with the other different EU legal acts? I mean, the connection by the implementation. So thank you so much. I think that was very shortly what we identified, and we are here just to start an exchange view with you and with your intervention. Thank you, Tim.
Dora, thank you very much indeed. And Benoit, I'm going to ask you to open your camera so you can join the discussion. And before I ask you to introduce yourself, Dora, just a quick question, well, a reflection and a question from me, and I think this will be something Benoit has views on. I mean, we know that travel and tourism is highly regulated in terms of financial protection, and some of that is sector specific, like passenger rights, like package travel, and package travel. I mean, there's a workshop tomorrow, which no doubt both of our associations are involved in on package travel, in fact, and how that might develop over time. And historically, it's been the case that legislation tends to catch up eventually, perhaps, with the nature of the market, what consumers want, how they behave, the sorts of distribution systems there are there. So I think one of the reflections I have is, you know, we know one of the things we struggle with is that the legislation sort of is running behind market developments. And certainly as regards some of the, you know, Olivier mentioned it earlier, has there been consumer detriment in the operation of the protection frameworks over the last 2 years? Arguably, yes, because consumers weren't given as much choice as they wanted. Do you want money or vouchers and those sorts of things? Lots of difficulty recovering money from airlines for prepaid tickets and so on and so forth. It was complicated, very difficult for agents and operators, very difficult for consumers as well. But this bit of legislation is not sector specific. So I think one of the things we'll get into when we discuss the implementation is, you know, what's the interaction of all these various things? And my question to you, Dora, just from a practical business perspective, is this affecting insurance provision? I mean, when you look at, you know, what's the potential downside, you know, if I'm a small business, is this a big risk for me? Because suddenly I'm going to get lots of letters through the door saying, we're going to sue you. From what Olivia was saying, it doesn't feel like a huge risk. This is not going to be US-style speculative litigation. So has it given any practical issues with regard to insurance and that kind of thing for your business?
Yes, thank you for the question. Right now, we all know that, first of all, the obligation for the financial protection is purely for insolvency. So that's always a question, because some people mix up, or there are different systems, even it's not harmonized at EU level, just we have in the PTD the main important elements and requirements how a sufficient insolvency protection system could work. Bracket, it will be reviewed now by the PTD, because we all know that since COVID, everything collapsed. So we have to put on a very, very new level, everything. This is my personal, professional and legal opinion. So therefore we are fighting together with ECTAA and with you. But this question that you are saying, because here we are talking about, and Olivier can confirm me about redress, so remedies, compensation, right? I mean, based on a consumer class action, this is something dealt by another kind of insurance, if we talk about professional liability and all these issues. So that was also a case sometimes in Hungary that something happened, you are right. So the TO was obliged to pay a compensation, but it was not insolvent. So, but they asked, of course, the consumers, but the money is there somewhere in the insurance, but it was not the case, because it's not based on the insolvency protection. That's a question for the PTD revision, that if the professional liability insurance will be included or not. As I saw from the questionnaire, there is a specific question on the topic as well. I know that in some countries, some member states, it's already a good system. In Hungary, we don't have an obligation or an obligation system for that. But yes, you are totally right. I mean, if you are an SME and then you can be involved for easier procedures to pay back, reimburse the customer, that could be, yes, a strength or a risk for the future.
Good, thank you very much, Dora. And I think that is one to keep an eye on. I'm just going to reference one question we already had from, and this was from Nick, who I think is participating as well. And this is something for us all to consider in the general discussion. So I'll say the question, hold it in your mind, and then I'll ask Benoit to introduce himself. So Nick asks, what countermeasures should be implemented to detect and curb speculative claims? So, is there a risk of a lot of speculative claims, and what could be done, certainly in the context of domestic implementation, to reduce the risk of that? So great question, Nick. That's going to kick off the broader discussion. But before we get to that, Benoit, would you like to introduce yourself? Welcome to the webinar.
Thank you, Tim. I will just introduce myself very quickly. My name is Benoit Chantoin. I am Director of Legal and Consumer Affairs at ECTAA, the European Travel Agent and Tour Operator Association. And I'm here because basically I was quite involved in the legislative process of the representative action. So I hope I can bring some insightful inputs. Thank you. And I would turn off and let the other panelists answer this question first.
Thank you so much. And I think, we do have expert people in the audience who will be very familiar with the legislation, but there will also be some people who go, is this something I need to worry about? Do I need to take this to the board? Is this some kind of strategic problem for our business? Now, listening to what Olivier was saying, listening to Dora's perspectives from someone running a business, I'm thinking not a huge risk, but there's definitely a lot of opportunity for difficulty. Olivier's points that there really is very little harmonization here. So there is not a Europe-wide framework here. It's highly fragmented, and there are lots of things which are not known. How many people need to be affected before it counts as a group? That's something that has to be sorted out domestically. What counts as a qualified entity? That also needs to be agreed domestically. So, there is still an opportunity to influence this, and there's still an opportunity for us representing the interests of industry to say, look, we all agree that you need proper consumer protection, and we look at it holistically. Does the whole system work so you don't have lots of duplicated forms of protection? you have a system that works, that promotes confidence to consumers, protects their money, makes sure that operators are liable for proper performance, all of those things. And we want to make sure that this is not adding unwelcome complexity. And, you know, in short, is this something people should worry about? Benoit, your hand is up. Over to you.
Sorry. No, actually, yeah. Just on that point, because I wanted to maybe add something on the potential impact that this legislation will have. As Dora said, indeed, that will concern a lot companies which have a group activity, but we should not forget the scope of the directive. The scope is actually concerning a list of different EU legislation, and if you are infringing those EU legislations, you might be well, that might open a case. And you have travel specific legislation, package travel, all the passenger rights regulation and so on, but you have also general consumer legislation such as unfair commercial practices and unfair contract terms. So you will have, in my opinion, two types of cases that may affect the travel trade. One is what Dora already presented, the group of travelers. The other will be just user of some website, because unfair commercial practices and unfair contract term will cover also everything that is within the sale department, and the way you will present some offer, the way you will present some price, or you will break down the price. So all those legislation which should be applied at EU level, if there is a how can I say, an infringement, that might open the door for a class action by a much larger group, in my opinion. And Olivier will.
Olivier, over to you, and then I'll go to a question we see in the chat. So Olivier, please.
Allow me to be, from a practical point of view, a little bit skeptical, honestly. We have seen since 2014 that there is not a lot of cases. One, these cases are not a walk in the park at all. They're heavy, they're work intensive, and they're very complex. So you need specialized lawyers, and don't forget, it is managed by the qualified entity. So if you have a group of travelers who want to sue a tour operator for damages that it suffered during a trip, for instance, let's say a cruise to see big, because it's the biggest I can imagine, for instance, is like 5,000 people who suffered, or 3,000 on board of a cruise ship, okay? First of all, and this is something we need to take into account, it is the qualified entity who pays for that. So they pick the cases, and these cases are extremely expensive. So they have seen now, in Belgium, I can tell you there are 5 or 6 cases. There was a big one, Ryanair, where because of the staff strikes, they sued for 16 million euro. But these cases never get to court, because for many reasons, because it's so complicated, they settle. And there was only one case that came to court. There was this Proximus case, and the judge said, no, this is not a misleading practice. After 5 years, and who's paying the bill? It's the QE, it's the qualified entity, not the consumer. So, and that's one part of it. But from an administrative point of view, these are huge cases. So I see these cases really for the diesel case, for, I don't know, there was a case pending, Facebook, Cambridge Analytical, for instance, where they try to have a maximum of consumers. And then just to pick in on your next question, Tim, in Belgium, the Consumer Association, they made a deal with Facebook. And the deal was heavily criticized, was that you could have a subscription to the consumer organization's newsletter. That was what the consumer got. So finally, we have to be very, very cautious that the system is not eliminating a kind of new business where cross-border qualified entities, for instance, together with law firms and third-party financiers, don't make a product out of that and go and look for some targeted companies. So I think this is the level we're talking about. I'm absolutely not afraid of a tour operator that when a trip went wrong, for instance, that there will be a class action. I don't believe that, because also at that moment, the consumer loses control because he's not a party in the case. Another thing, he has to prove his damage. he has to prove his damage. So all these cases, let's say, to come back to my cruise, you have 3,000 people, all their damages will be different. Material and moral, maybe. Is a QE really going to be interested to go and have a look at 3,000 cases where there's a child who fell from the stairs and this thing like this? I don't think it's really going to happen, but maybe I can be wrong, but this is too individualized to be part of a real class action in the spirit of the directive. They tried in Belgium with the first case was in the travel, was Thomas Cook Airlines, was a passenger rights case for 180 passengers from a flight from Tenerife. That was clearly a test case. It's not going to happen anymore. For 180 people asking 300 euro, this is impossible. It's too cheap. The amount is too small. And you need a lawyer and the procedure as well.
That's clear. And I think that'll be a reassuring message that, you know, if a particular tour is subject to difficulty, is that a likely candidate for class action? Really not. And I think, Dora, your point about existing, you know, resolution mechanisms, so whether it's formal arbitration or something less formal, I mean, the point is that's very standard for consumer-facing travel businesses of all kinds. I mean, it's a requirement, and there will be domestic varieties of it, but on the whole, they work. And you know, not having, with the greatest respect to Olivier's profession, and he would be the first to say it, you know, you're not going to go to a law firm or a QE to solve your problem first. You're going to go to the provider and try and seek redress. And if you don't get an adequate response, there is a trade mandated framework for you to get a response, because that agency or that company is part of a framework that has consumer redress in it. So travel and tourism really already has a very sophisticated framework. And I think where we're keen to make progress is to make sure that that is sufficient and it's providing a fair result both for consumers and for industry. I'm quickly going to jump to a question in chat, which is from Priya, morning Priya, who is London-based and is selling packages and looking at insurance options. And I think so two things to respond, Priya, and others may chip in. Because you're not within the EU as an entity, this does not apply, is the short answer. So no problem there. It may have some impact if you're contracting with entities within the EU who are adopting a slightly more defensive terms and conditions when they're, you know, within the supply chain. And we've certainly seen historically, Benoit has certainly seen a lot of it, where operators based in the UK are seeking to manage their own liability by passing on indemnity clauses and so forth to providers in the EU. And that's caused difficulty B2B within the supply chain. But I think that's a little bit of a separate question. And in general, an operator needs to look at two things beyond the statutory compliance, and that's professional indemnity and public liability in the UK. So I think your providers in the UK will not be affected by this EU directive. We've got 10 or 12 minutes left. Olivia, your hand is still up. I don't know if that's a new one. It's okay. But back to Olivier, implementation is a complicated animal, and people running travel businesses are busy. People in trade associations and in law firms have got time to look at this, and there is an opportunity to input at a domestic level to try and influence the sorts of decisions that are made. So could I ask you to put up the last slide you had in your presentation with regard to implementation, Olivier, and we'll unpack some of that and see if there's any action that we or members of the audience ought to be taking to influence the result in the member states who are yet to implement this. So back to you, Olivier.
Sorry, I should unmute. I'm muted? No, you hear me? Yeah.
Yes, we can hear you fine, Olivier, and we can see the presentation.
This is just a list. I see you mentioned random and not exhaustive, but we can go much deeper into this, but we don't have time for that. It's just for you to have an impression of some matters where the directive gives a lot of freedom to the member states, and one is the scope of the directive. Benoit mentioned already, confirmed that there must be an infringement of one of the legal
Olivier, could I interrupt and ask you to put it to full screen just to make it easier for people to see? Thank you.
I can do that. There you go. So the first I would say is the material scope of the directive. Benoit confirmed you have indeed, it's for the moment that you need an infringement of one of the legal instruments attached to one, but the national government can go larger, can extend that. In Belgium, for instance, it's every contractual violation, which makes it very large. You understand immediately that this is very different. It's also a contractual violation, not only violation of a specific legal instrument. Two, of course, the designation criteria of domestic and cross-border entities. If these are different, then we have a problem, because the idea is also to create cross-border class actions, but in some countries, maybe there will be normally a mutual recognition, but if the criteria are completely different, and then you can have differences between the member states. Then, of course, the group of consumers. What's a group? What is a group? Is it 100 people? Is it 300 people? Is it 2? So if one member state starts its 1,000, then, well, then you don't have a group of consumers for the other member states. That's not a difference between the member states.
Sorry to intervene, but yeah. I think that's a very important point, that mainly we could fight to increase as much as we can the numbers, of course, because of the characteristic of our activities. So, but you are right, Olivier, with the example, for example, a cruising, but even it's different. It's very different from the planning and from the operation side. That if we are sending the travelers there, and who is the operator, who is the main operator, the ship cruise company is behind, or we sell it as a package. So every case is different, but I think this is a good point to try to increase the number, right? Because we are not dealing with thousands of people, especially if we're talking about the leisure segment.
Yeah, this could be an interesting item for national government, because you also should know that courts are in general not so extremely happy. They're a bit reluctant to have cases. Yeah. So if you have a class action for 100 people, okay, fine. But courts are not organized. If you have a case of 100,000 claimants, 100,000 consumers, it's just impossible. I have to say that in our court, we have a case of 5,000. The graph, so the staff cannot follow, because all these consumers have to warn the court to say they want an opt-in or opt-out, for instance. That takes a lot of money. It takes months. So there is a high burden for courts, and government should realize that. So the question is, how do you organize these group consumers? Is there a minimum? That's something up to the national governments. And I mentioned it already, the opt-in and opt-out mechanism is extremely important. You have the QEs who want, of course, opt-out mechanism, because they pick the cases and then they represent all the consumers, even those who don't want to be or don't indicate that they don't want to be represented. That gives them a far larger leverage to proceed. While I think there is a tendency in some countries and in some courts to say, no, don't see this too big, it should be an opt-in. But then again, it's the national government who can decide. Also, which court? Will it be an administrative court or a judicial court? Is there an exclusivity of courts, for instance, in Belgium, Brussels court, or all national courts, like in France? This is also something that the member states must decide. There is a procedure of admissibility of claim, just to make sure that there is no, again, abusive situations. So there is a provision in the directive that states that there is at some point, there must be a kind of filter, just to avoid, again, these huge American-style class actions that the judge can say, no, this is where it stops. It is not admissible, because there's a prima facie assessment of the infringement. We don't believe it. So how is this going to get organized? This is also something that's up to the member states. In Brussels, for the moment, there is a first hearing where the court assesses the infringement. He said, no, this is not serious, and you cannot appeal. This is different in other countries. What are the member states going to do? Another question, which is also important for traders, is a mandatory cooling off period. Once the case is admitted, it's admissible, Will there be a cooling off period of, for instance, 6 months, when parties are obliged to negotiate? Right? Some countries that doesn't exist, but that's a proposal. It exists in other countries. And then about the procedure itself, there's a lot of things to say. You know, when you ask redress, when you ask compensation, you need to prove your damage. That's a principle, that's a legal principle. So how do the QEs are going to present evidence? Okay. What about the delays also? For instance, in some countries, there is no fixed delays. In Belgium, there is a delay. Admissibility is within 2 months, then there is 6 months, and then there must be a court case. It's not the case in other countries. Is this something that's going to be implemented in some countries? And then one that is, the third-party funding, which is something that I'm very scared of, not scared, but I know the Commission, because the Commission is saying there is a high risk. I think it's at least 10 times in the directive it's mentioned that there is a risk. If the Commission says there is a risk, well, there is a risk. There is a risk that we could lead to kind of American-style class actions. The question is, what is going to be what conditions will there be for third-party funding? It's up again to the member states to accept it or not, because sometimes you have indeed QEs don't have the money to pay the expenses to file a lawsuit, and two, to pay after that when they lose the case, to pay all the expenses to the trader. Maybe some consumer associations will go bust or cannot afford that. That is one of the reasons there is a possibility of third-party funding. Which countries are going to accept it, at what criteria? And then one last one, but that's not about strictly the implementation. I think there is a huge opportunity missed because of the cross-border. One of the ideas is to have cross-border class actions, but the directive says nothing about these cross-border actions. So what happens if several QEs, qualified entities, start different cases in different countries? We have a clear risk of different procedures, but also different outcome. And that's a very missed opportunity in the directive. So maybe it can be settled at the level of the member states, because the directive could have provided in some kind of priority, or for instance saying, no, when one case is launched, this case must be handled before this court. And the other QEs can intervene, because the QE, for instance, a French qualified entity, pursuant to the directive, can start the case in Holland, for instance. But all these things, we speak about the cross-border class action, but the directive is not giving any solution. So this is maybe something that can also be solved at the level of the member states. And so on and so on. This is only a little teaser about the work that has to be done by the member states in the implementation procedure.
Well, that is, it's a lot to consider, but on balance, I think your concern about the third-party funding is very clear, but it does not sound as though day to day, I mean, as you say, the amount of jurisprudence on it so far is very limited. And there's a paradox in that you need a bigger group to qualify, but the administrative burden of assembling the evidence that's going to be acceptable by a court is very high, and that cost is borne by the qualified entity. So, you know, unless someone really sees financial opportunity, it doesn't feel as though this is something that's going to be impactful day to day on normal consumer relations for operators. But we've got a minute or two left. I think this has been a very, very helpful survey of where we are and the key things to press for at a domestic level. But if I could ask each of you just for maybe 20, 30 seconds of any final reflections, but next steps are do stay in touch with your national associations. ECTAA and ETOA on this will keep you informed, but thank you very much for joining us. So I'm going to ask Benoit and then Olivier, and close with Dora for any final remarks, and then I will close this session. So Benoit, over to you.
Thank you, Tim. Thank you for the organization. Maybe my take would be, I do agree that in the best case scenario, it can have a very limited impact and maybe just be a failed directive that will not be used. The problem being also that there are so much flexibilities and leeways in this directive that there is always a risk that we may end up with a procedure that can be completely abusive from at least a industry point of view. So we have to be on the lookout and be careful that some safeguards are still put in place in order to make sure that this directive remains proportionate. And I thank you very much, and goodbye.
Thank you very much, Benoit. Olivier, final thoughts.
I think if justice can be rendered more quickly and more efficiently, this is great. Okay, and this is why I truly applaud this kind of directive, because it can help indeed for consumers with little financial interest to have access to justice. But I don't think we should overrate the directive in a day-to-day business in the travel sector.
That's very clear. Thank you, Olivier. And Dora, last word to you.
Yes, again, I can just emphasize, because it's really now a big question how the national implementation with such minimum harmonized rules will be, yes, finally set out. So I can just, again, advise to everybody, such as we are doing right now in the market, it's really, really challengeable, but we do be very careful, be prepared, and then hopefully we can avoid of any other further negotiations or problems with the consumers.
Here's hoping. Thank you, Dora. Thank you to our audience for joining us. It's been great to have you there. Thank you to my colleague Sophie for running things behind the scenes. And from all of us in Brussels and Budapest, have a very good day. Thank you.
Bye. Take care, everyone. Bye.